I'm Roger Citron. I'm a professor at Toro Law Center. This is a Toro Law Review podcast. We're delighted today to have as our guest Professor Ilan Wurman. He is a professor at the University of Minnesota Law School, where he teaches administrative law and constitutional law. And today we will be talking generally about the president's removal power under Article 2. And we will take a bit of a deep dive into a case to be argued before the Supreme Court next week. That is the Trump versus Cook case. And I know we're going to get into it. So let me start by asking, Ilan, tell us a little bit about yourself, please.
Sure. Well, you hit the most important part, which is I'm at the University of Minnesota at the law school. I teach constitutional law and administrative law. I write on separation of powers, administrative law, executive power, the kinds of things you'd expect because we're having this conversation today. I write a lot about the removal power, presidential power, and I did write an amicus brief in not this case that we're going to discuss today, the Cook case, but a different case that I do think we're going to touch on as well, the Trump v. Slaughter case. And so that's generally me and my background.
Thank you. And let's start with the Slaughter case. It was argued in December, and there's sort of a conventional wisdom about what the outcome of that case is likely to be. Can you sort of set the stage for us by saying a little bit about Trump v. Slaughter and, situate it historically in connection with the Supreme Court case law here?
Sure. So the case involves what are called independent agencies. What are independent agencies? Well, ordinarily, the president has the power to freely remove principal officers in the executive branch. So, for example, the Secretary of State, the Attorney General, the Secretary of Defense, I guess now the Secretary of War. And that's how things were done for a long time. But starting in 1887 with the Interstate Commerce Commission, Congress started restricting the ability of the president to remove certain principal officers. So Congress started creating what we now call independent agencies. Usually they are multi-member, so say there are 5 members or 7 members. It's a bipartisan composition, so you can only have majority plus one as members of a particular party, and then everyone else has to be the other political party. Their terms tend to be staggered. And for purposes of this discussion, they are protected from what is called at-will removal by the president. So they're protected through these provisions that are called for-cause removal protection. Now, sometimes the statute just says cause, for cause. Actually, the Federal Reserve statute just says for cause, which is kind of interesting. But many times they actually specify inefficiency, neglect of duty, and malfeasance in office. And what is important about these for-cause removal protections is it is believed that these removal protections are what make the agencies independent. Independent of what? Well, independent of political actors, including of the president. The theory being, suppose, as we all know, Congress delegates in relatively broad terms, especially today. So suppose in administering the policies of the Federal Trade Commission, a reasonable person could read the statute and say policy A is consistent with the statute. Another person could say policy B is consistent with the statute, and a third person could say policy C. I mean, you could have policies D, E, and F as well. The point of the for-cause removal protections is suppose the president wants policy A, but the independent agency wants policy B. Well, disagreeing with the president about that isn't inefficiency. It's not, inefficiency. What's inefficiency? Inefficiency is like, I guess, not showing up to work until 10 a.m. I mean, I think even government officials show up before 10 these days. So that would be something like inefficiency. Mere policy disagreement wouldn't be. Malfeasance in office, I think that's kind of like embezzlement, perhaps, things like of that nature. And then neglect of duty. Well, neglect of duty to the statute, right? And they're not neglecting their duty to the statute if the agency's policy position is within the scope of the statutory authority. So again, just to summarize, the idea is these independent agencies are independent by virtue of this for-cause removal protection. Now, the Supreme Court, in a case called Humphrey's Executor in the United States in 1935, upheld the constitutionality of these agencies. President Roosevelt tried to remove a commissioner without stating any cause because of a mere political disagreement, policy disagreement. The Supreme Court 9-0 upheld it in an opinion that is on shaky textual and historical grounds, and maybe we can talk about that. And in the Trump v. Slaughter case, it is that precedent, Humphrey's executor, is squarely presented, and the court will revisit it because Slaughter was an FTC commissioner whom the president removed without citing any cause. So that's what brings us to the Slaughter case and what the court's going to do with Humphrey's executor and what is the correct original understanding of executive power and the removal power and the necessary and proper clause. And so I assume that's what we're going to get into.
Yeah, and while we're back in 1935 with Humphrey's executor, um, when I teach administrative law and lay out this background, um, I always, of course, and I think the case books do this, right? We start with Myers as a way of juxtaposing um, the president's general removal authority with what could argue to be an exception or a separate sort of area with Humphrey's executor. Um, and so uh, the other thing I wanted to just sort of add, and we can bring Myers into it or not, was it's kind of interesting that Humphrey's executor in 1935, right, when there's sort of this um, conflict between the president and the court, that this is a 1935 decision, and it's a unanimous decision. Um, the last wrinkle, and this is something that a friend of mine and I, we've talked about, and I harp on, and I wonder if you find it to be significant too. Um, it was a suit for damages. That is, uh, he wasn't trying to keep the job. Instead, it was a claim for compensation. And somehow that seems to help, in my view, and this is again from a conversation with a friend who teaches in this area as well, it seems to help explain, make the case easier for the court. So having said that, those three different things, can you tell us a little bit, do you want to sort of elaborate on how we should understand Humphrey's executor coming into Slaughter, which is where we are?
Yeah, so briefly on the last 2 points, it is interesting that a lot of these removal power cases have historically been salary suits. And this goes to the question of equity jurisdiction or equitable remedies, because if the remedy at law is adequate, you typically don't get an injunction. So United States v. Perkins involved an inferior officer, a naval cadet engineer who was discharged contrary to the statutes. His services weren't needed anymore. And he got pay in the Court of Claims. So he wasn't reinstated, but he got his salary. Myers was a salary suit. That's the postmaster case that you mentioned prior to Humphreys. Humphreys was a salary suit. Weiner v. United States was a salary suit. It really wasn't until Free Enterprise Fund, I think in 2010, the dual for-cause removal provisions, that the Supreme Court started entertaining challenges from private parties arguing that the agency had acted unlawfully because of the impermissible removal restriction. And the Slaughter case is different because it's not a salary suit. It's not a private party claiming the agency has unlawfully exercised authority because of the unconstitutional removal provisions, but it's actually the removed officer is now seeking reinstatement. And I am not a remedies expert. It does seem to me the remedy at law is adequate if there, which raises the question though, if Congress never waived sovereign immunity and didn't open up the Court of Claims for damages, would then you get reinstatement? I mean, it's interesting. It's weird. You need a remedies person on there, but I doubt the Supreme Court will get to that question because you only get to that question if the merits are decided a certain way, if they conclude that Slaughter was wrongfully removed, and I don't think they're going to do that. I don't think they're going to come to that conclusion. On the unanimous, yeah, it's kind of interesting. It's the dissenters in the Myers case joined with the conservatives who didn't like Roosevelt, right? And they liked the old way that the Federal Trade Commission was administering the policies and did not want Roosevelt to stack it with New Deal appointees. And so I think they kind of let their political biases get the best of them. And then you have that 9-0 decision, which is actually very interesting. Okay, well, on the merits. So I think it's important to separate two different classes of officers. So first, this just goes to the merits of the Slaughter case, and we can talk about Myers, which came, of course, before Humphrey's executor, because it's all connected. So the Constitution doesn't say anything about the removal of officers. It provides for the appointment of officers. It says principal officers. Who are those? We can get into, but just think Secretary of State, Secretary of War, Secretary of Treasury, and so on. The principal officers must be appointed by and with advice and consent of the Senate. So the president and the Senate together share in the appointment of these officers. This mechanism is also the default rule for all other officers as well. But principal officers have to be appointed in this way. And it's the default for all other officers as well. However, Congress can choose to vest the appointment of inferior officers in the principal officers, in the head of the department, or in the courts, or in the president alone, though that's quite rare. So we have this default appointment process, and then we have this inferior officers appointments mechanism that Congress can choose to invoke. And what the Myers decision basically said is that the removal power comes with the appointment power. And I actually think that's right as a historical matter. And so I'd like to unpack that a bit. But the Myers decision basically held that as long as you're appointed by and with advice and consent of the Senate, the president, the theory is the president is really doing the appointing. I'll explain a little bit about that. And the president has to have the removal power. But if the inferior officer is the appointment is vested in the department head, the president doesn't have to be the one to remove that officer. It could be the department head. So in other words, if Congress assigns the appointment power to the head of the department, the removal power comes with it. Okay. So that's the Myers decision. And I want to unpack it a bit because I think it's probably right as a historical matter. So why didn't the Constitution talk about the removal power? And I think it's because it was understood that removal was incident to appointment. And this kind of makes sense because one who appoints can remove simply by making a new appointment. So there are lots of commissions from like colonial Virginia and other colonies where the commission would empower this new officer who was appointed, and then it would say, and this previous office holder is hereby displaced. Thomas Jefferson wrote a note in 1779, I think, and again later, that all lawyers know that removal is incident to appointment, right? And so they come together. And so why does the Constitution not mention anything about removal? This is quite interesting. I think it's a quirk of the constitutional drafting history. And by the way, what I'm about to say is, somewhat, I don't think it's controversial, but it's somewhat interesting because Michael McConnell, a leading scholar in presidential power, says it's inexplicable that the Constitutional Convention didn't talk about removal. But what I'm about to explain, I think, explains it. So until September of 1787, until the very final draft that comes out of the Committee on Postponed Matters, okay? This is kind of a big thing to postpone, which is kind of funny when you think about it. But until then, the Senate had the appointment over certain officers, ambassadors and judges of the Supreme Court, and the president had the appointment of all other officers. So you didn't need to specify the removal power because the Senate would remove ambassadors by making new appointments. They would remove judges by making new appointments, save for the fact that lifetime tenure was also put in there for judges of the Supreme Court, right? The president would remove officers by making new appointments. You didn't have to talk about the removal power because removal was incident to the power of appointment. It was only in the Brearley Committee, the Committee on Postponed Matters, in the second week, I think, of September of 1787, where the draft constitution, after postponing all these matters, all of a sudden gave all of the appointment power and shared it between the president and the Senate. So this now raises this interesting question. Okay, well, now that the Senate and the president together share the appointment power, does that mean that the Senate and president together remove by making a new appointment? This seems to follow from the common law maxim. But James Madison and others said, well, yes, that would make sense, except for the fact that there are other things in the Constitution that speak about this. For example, the Take Care Clause. If it's the president's duty to take care that the laws be faithfully executed, how's the president supposed to do that if the Senate could put a check, a legislative veto, if you will, on the president's removal? Another possibility was that Congress had discretion under the Necessary and Proper Clause to place the removal with the president alone or with the president and Senate together. But this is also a problem because, again, if the Take Care Clause suggests that the Senate can't have final say, can't have a legislative veto over whether the laws are being faithfully executed, then I don't think Congress under the Necessary and Proper Clause could choose to give it to the Senate either. Now, you may or may not be persuaded by the analysis I've just given, but it was James Madison's analysis. It seems to have been similar to Fisher Amos's analysis in 1787, and it seems to have convinced a majority of Congress in 1789 who specified that the removal power would be in the president. They wrote it in such a way that it would not appear to be a conferral of the removal power. There's some debate. So in other words, it was their interpretation of the Constitution. It was It was the Congress's interpretation that the president has a removal power as a matter of constitutional right. There's some dispute about this in the modern scholarship in terms of the voting coalitions. Some people may have voted for that thinking that Congress had discretion to do it, and others think it was is a constitutional right. But for a long time anyway, it's been called the decision of 1789, and for a long time it has been understood to be sort of this constitutional construction by Congress, concluding that the president must have the removal power. And I find that argument, quite persuasive, because again, the I didn't say this part, but the executive power, right, was understood to include appointment because the executive power, can't be the laws can't be executed by one person alone. So it was understood that the executive power entailed the power to appoint officers to assist in law execution, and removal followed from appointment because it was an incident to appointment of the common law. So another argument that Madison made is the executive power is the power to supervise the execution of the laws, and that includes appointment and removal. And the Constitution puts a check on appointment by giving the Senate a say rather than removal. Okay, look, that's the merits of the question of who has the removal power. It doesn't answer the precise question in Humphreys and Slaughter, which is okay, assuming the Senate does not have a legislative veto, assuming the president has this power, can Congress check that power through for cause restrictions? That's a slightly separate question, right? As to who has the removal power to begin with. And even if it is the president, we conclude it's the president, can Congress shape it, structure it, limit it in certain ways through the necessary and proper clause? And that's really the precise question in Humphreys and Slaughter.
So thank you, because really, that was both very detailed, and I mean that as a compliment, as well as, one sort of point followed the preceding one. The thing I want to ask is, so is there anything, and this is I ask this quite sincerely, is there anything sort of, post the founding, and I'm thinking of, the New Deal, the 20th century, that we should be taking into account as we get into the Slaughter, into the particulars of the Slaughter case. And and in asking this, I understand that, I went to law school. I graduated in '92. Originalism was just sort of getting started then, and so, what you've just discussed, I'm virtually certain would not have been discussed, when I was in law school during that period of time. That is, there was a real sort of New Deal centric approach to understanding administrative law, and even I think more specifically what we're talking about now. So that's a
Yeah,
series of statements. Go
so
ahead.
so obviously practice near in time to the founding is illustrative, probative of original meaning. As you get farther away from the founding, it becomes less probative of original meaning. Now, it might be indicative of of what we call liquidation, or what the founders called liquidation, or it's unclear how many people thought in these terms. James Madison certainly did, but what did the founding generation generally do when a constitutional provision was ambiguous? Well, they thought that within the range of ambiguities, the decision would be liquidated over time. It would be settled over time, not through a single Supreme Court decision, but through a series of discussions and deliberations and adjudications across multiple branches of government, multiple court cases with the general acquiescence of the people. So to give a good example of this, the Bank of the United States, which doesn't unrelate. It's not unrelated to the Federal Reserve question, which we're going to get into. But there was a question in 1791 whether Congress had the power to incorporate a bank under the necessary and proper clause, and Madison argued against it, said no, it's too great and important a power to be left to implication under the necessary and proper clause. The House disagreed with him. The Senate disagreed. There was a debate in Washington's cabinet where there were different views. Washington signed the bill. Eventually, the bank was rechartered. And when it was rechartered in the War of 1812, Madison was president, which is kind of funny. So does Madison veto the bank on the grounds that he had thought it was unconstitutional? Well, that would have been quite embarrassing to him because it turns out the bank was quite useful, especially during the War of 1812, to facilitate loans and funding and payments and things like that. And in his message signing the bill, he said, basically, look, this question has been settled. However open it might have been 15 years ago, it has been settled, through this series of discussions and deliberations. And interestingly, and so he did not veto it despite his view. It had been sort of liquidated. Chief Justice Marshall in the court in McCulloch v. Maryland didn't address the constitutionality of the Bank of the United States until, was it 1819? I think. So like almost 30 years after the fact, right? So liquidation doesn't just happen in the courts. So can you make an argument that independent agencies are sort of liquidated in some way? Well, you would have to show that it's within the range of ambiguous meaning. And look, like certainly there are the it's you can make a plausible case here. Actually, the best briefs I saw in the Slaughter case was, I think, from the Center for, I think it's called the Constitutional Accountability Center. They're like these progressive originalist scholars, and they really did this ingenious brief where they said, I think it's wrong, but it was ingenious. It was really, really good. And you got to give credit to the other side sometimes. And they said, what could be more ambiguous than the question of removal? I mean, it doesn't say it anywhere. It's not mentioned in the Constitution. So what could be more ambiguous? And then they go through all of these historical precedents, starting at the founding through the Interstate Commerce Commission and the New Deal, to show that it has been liquidated for over a century of practice. This is quite ingenious. And I think that's the strongest originalist argument on the other side. The problem for the argument is when you look at the historical practices near the founding, they really don't support the proposition that the president can't have control over the principal officers. So they talk about the Bank of the United States, which we'll talk about. The Bank of the United States was just a bank. It didn't exercise any power. It didn't exercise any regulatory power, which is why I think the Federal Reserve, by the way, is different. Okay, there was a sinking fund commission on which the Chief Justice and I think the Vice President were a member, but three other principal officers were on the commission as well, and whom the president could remove and the president could direct. And so the president had a majority of appointees on that commission who were responsible to him. I think the sinking debt fund commission was similar in its structure, though I'm a little bit less familiar with that. And so you go through all these examples, and it really wasn't until 1887 where Congress changed this. And so that came 100 years after the Constitution was first written, 99 years after it was ratified. It's a little late in the day to liquidate a contrary practice. And that also assumes that you are within the range of ambiguity. And if you think I'm right about executive power includes appointment and appointment includes removal, and that this means the president has the removal power, it's a little late in the day to say the president's removal power can be checked. Now, again, look, we haven't done the necessary and proper clause analysis just yet. Maybe Congress has some authority to shape the president's power, assuming it belongs to the president. And so really these historical precedents go to that question. Can Congress create these four cause restrictions? But again, with the sinking fund and the War Debt Commission and the Bank of the United States, it's just the president had control over the majority of the officers. So they're not strong precedents for the proposition that Congress can create these four cause restrictions.
Let's
There's a lot there. So
no, and I was going to say, we haven't even gotten into to the Trump versus Cook case. So I want to get to, and of course that means I want to get to Slaughter. So let's take it up to the last year or so, to late last December when the case was argued. And I don't think this will come as a shock to you or anyone else listening. That is, it seems quite likely when you said the issue presented is, will we, should the court overturn or set aside Humphrey's executor? The answer seems to be almost certainly yes. Almost certainly yes. And I think, let me ask the question this way, which is, from the oral argument, it's always reading tea leaves, but nonetheless, from your work on the case and from the oral argument, do you have a sense of how that decision may be written? I can't say will, but is likely to be written based speculatively.
Yeah, well, we really don't have to rely on oral argument because we know what five of them have said on this issue already in other cases. So, as an initial matter, it should be said that Humphrey's executor is clearly wrong on its reasoning. And there are actually 9 votes for that proposition on the Supreme Court. If you look at the Selah Law case and you look at some of Justice Kagan's footnotes and dissent, everybody agrees that Humphrey's executor's reasoning was wrong. Humphrey's executor relied on this idea that the FTC was exercising what it called quasi-legislative or quasi-judicial powers. There's no such thing as quasi-legislative or quasi-judicial power in the Constitution. There's legislative power that has to be exercised by Congress. There's judicial power that has to be exercised by the courts. And then there's executive power. And the question is, of course, what is the president's relation to executive power? But there's no such thing as exercising power that is legislative in nature that doesn't have to be exercised by Congress, or quasi-legislative or quasi-judicial, but doesn't have to be exercised by the courts, right? It's either legislative, but the FTC isn't Congress. It's either judicial, but the FTC isn't a court, or it's executive. In which case, the question arises, what is the relationship of the president to executive power? So this idea of quasi-powers is simply wrong as a historical matter. Now, I want to be clear, and I should emphasize this is really getting technical, but it's important, and I've written about this, which is why I'm kind of passionate about this. To say that there are only three powers, legislative, executive, and judicial, doesn't mean there isn't overlap in the functions of those powers. So when the president promulgates a rulemaking, think of President Washington's first rulemaking with respect to the invalid veterans of the Revolutionary War. Congress assumed the payments of the Confederation Congress to the invalid veterans, and under such regulations as the President of the United States may direct. And Washington and Henry Knox promulgated a regulation saying, show up with these vouchers, proofs that you were injured, show up in these 2 times a year, and we'll give you 2 equal installments. Is that something Congress could have done? Of course it could. Congress could have passed a law promulgating that regulation. Does that mean when President Washington promulgated the regulation, it was an exercise of the legislative power vested in Congress? Does it violate the non-delegation doctrine? And the answer is no. It turns out some things, it's true, can only be reached by legislative power. And that's the realm of the non-delegation doctrine. Call it exclusively legislative functions, the establishing of intelligible principles, the regulation of private rights, the deciding of important subjects, whatever your test is. But other things Congress could do, but also the president could do because it's sufficiently detail-oriented or sufficiently unimportant or doesn't affect private rights or it's pursuant to an intelligible principle such that the president, in making the regulation, would be exercising executive power, not legislative power. So this might be what confused the court in Humphrey's executor, this idea that there are overlapping powers and overlapping functions, public rights. Courts can adjudicate those, but so can the executive and so can Congress by private bill. We don't need to get into that, but so there is such a thing as overlapping functions, or what I've called exclusive powers, but non-exclusive functions. Exclusive powers with overlapping functions. Some things can be reached or done by an exercise of more than just legislative power or just executive power or just judicial power. And that's what might have confused the court in Humphrey's executor. So anyway, the reasoning, though, of quasi-legislative, quasi-judicial, that's wrong. So the question that the court's going to have to decide, and it's going to have to write an opinion, is, okay, its reasoning was wrong. So now, on the merits of the text and history, the originalist question, what is the president's relationship to the removal power or to the executive power? And I think they're going to say the following. They're going to say 9-0, I think, by the way, for this proposition, the removal power belongs to the president. Because of the things that I've said, appointment is incident to executive power, removal is incident to appointment power. The president must have the ability to remove for purposes of the take care clause. That's going to be 9-0. Then it's going to be 6-3 on the question whether Congress, pursuant to the necessary and proper clause, can limit that power through 4-clause removal restrictions. Now, my view is really simple about this. Just, once you've acknowledged that the president has the removal power, it's kind of like asking, can Congress limit the reasons for which the president might exercise the pardon power? Can Congress pass a law that says the president, right? So the argument, okay, I'm getting ahead of myself. So let me back up for a second. The argument that Congress has this power under the necessary and proper clause is that Congress has the greater power to create the office in the first place. The Constitution doesn't create the Interstate Commerce Commission, the Federal Trade Commission, the Department of War, the Department of State. It doesn't create these things. Congress does. And so Congress's greater power to establish the office includes other, lesser powers like the power to give it particular duties, the power to structure the tenure, as in you'll only have a 4-year term of office or a 6-year term of office. You can have, a 5 assistant attorney generals or 10 assistant attorney generals, right? Congress can do these things. They can even establish qualifications like the solicitor general has to be learned in law. I think that's still in the books, right? And so the theory is if we could do all of these things, it can also limit the reasons for which the president can remove the officer. That's the theory. The greater power to create the office includes the lesser power to structure the office, including limiting the reasons for which the president might remove. But I don't find that persuasive because look at the pardon power. So Congress has the greater power to create federal offenses. No one says that Congress's greater power to create federal crimes includes a lesser power to tell the president he could only pardon people convicted of those crimes for certain reasons. I mean, that'd be crazy. Like, you could only pardon somebody committed of wire fraud if the following causes apply. I mean, that would seem. Does anybody think that that would be constitutional? And if that's true, why would the removal power be constitutional? Okay, 6-3, and then that's going to be the debate over this greater power. Does it include lesser power, or does it actually derogate from the president's removal power, executive power, having these four cause restrictions? That was a lot. I think I've answered your question, which I've since forgotten, but I'm sure I've answered it. So I'll stop there.
Yes, no, because we were talking about what's Trump versus Slaughter. If you had to discuss what the
Right,
court's
right.
decision will look like, and you have said there will be two parts, or two aspects to be addressed by the court. Um, the I, I do want to let's get to the Federal Reserve. I mean, we might circle back in this discussion. One of the things that you said, I think, early on in our discussion, um, was that on the emergency docket, um, the court has indicated, that is, it hasn't said much, but what it has said is the Federal Reserve is different. The Federal Reserve is different. And I'll ask it in two ways. That is, what's your sense of, to the extent that you can infer from what the court has said about the Federal Reserve recently, um, why it thinks the Federal Reserve is different. And then this part two is because I think, and by the way, this is where I thought you would come out from what my background research was. You don't agree. You don't agree. So part one and then part two, please.
Okay. Is the Federal Reserve, first of all, there's a little, I really shouldn't get super political when it comes to these things, but it's not unrelated. It's like asking the question, are independent agencies ever actually independent? And I just don't think that's true, right? I mean, like, there is such a thing as apolitical neutral expertise, right? Like, you can say, this is how you build a nuclear bomb. Okay. But the Department of Energy can't tell us whether we should use a nuclear bomb. It can't tell us whether we should build a nuclear power plant. I mean, it could tell us certain things about the science and so on, but 99% of the things that agencies do are not particularly controversial, but it doesn't mean that they're apolitical in the sense that there are always costs and benefits. There are always moral and political choices to be made. And I think it's just it obfuscates the question, the issue, what's really going on to say that there is such a thing as this kind of true independence. Is the Fed is the Fed different from like a real life perspective? And then I'll talk about the constitutional question. Like, I don't know. Like, I look at the Fed and I think they probably caused the Great Depression. But, Milton Friedman was a, huge influence on me. I think the Fed has done everything wrong and almost every opportunity, that it could have done things wrong. I think the Fed in an election year for the president that is favored by a majority of Federal Reserve governors, they tend to lower interest rates and do some quantitative easing, and make the economy look temporarily, superficially stronger to help them get elected. So I just don't see why people should believe, right, that the Federal Reserve, in fact, can be truly independent or apolitical or neutral in a way that other agencies just aren't. Now, part of the reason for that might be that, and this gets into the constitutional question, the Federal Reserve does a lot more than the Bank of the United States does, right? The Bank of the United States was just a bank. It was a very powerful and influential bank because the United States put its treasury deposits in the bank, which allowed the bank to create a uniform national currency, and backed by this supply of funds, right? Banknotes. It wasn't like greenbacks. It were banking notes. So the Federal Reserve, even if all it did was operate as this central bank, that was just so important because all most of the reserves were there, and it was sort of like this insurance backstop, and so that the rates followed what the Federal Reserve did. Even then, I don't think it would be apolitical. But at least then, it might be just like a private bank, a very powerful private bank, a powerful private bank in which the United States has its deposits, in which the Treasury keeps its funds, just like the Bank of the United States. But the Federal Reserve happens to do a lot more than that. It regulates uh, all national banks. It tells them how much capital reserves they have to have. It tells us, the limits on the loan terms that they can have. And it's got tons and tons of regulations of banks. So is there an exception to executive power for financial regulation? I haven't seen it. I haven't seen it. So if you strip the Federal Reserve from all its regulatory power and just keep this banking function, it would still be very important and would still have this downstream effect in setting interest rates to a large degree. But certainly until it does that, there's no Federal Reserve exception. And so, like, I just don't understand why the Supreme Court, in its interim docket, said that. I guess just the Federal Reserve is like the third rail, or like people just can't touch it. Which again, I'm not convinced of because I think they've messed things up for much of history and that they're actually political and it's just we're pretending that they're not. So I don't see why this needs to be such a third rail. But certainly from a constitutional perspective, I don't see the difference.
Um, Fair enough.
Makes
Can
me
I,
radical.
um, well, this is a joke, but consistency can do that. The two thoughts. And let me start with, I guess, the narrower one, which is that I think, the in some ways the path that we have been recently, that is the path that sort of led us to this discussion today, arguably begins with SELA or SELA law in 2019. That's not as clearly true with the Federal Reserve as it is with Trump versus Slaughter. But my recollection is that Justice Kagan in her dissent, this is I'm sort of pushing back on. Oh, uh, there should be no exception for financial regulation, if I'm characterizing what you said correctly. And I think Justice Kagan's dissent, that is, if it's not explicit in the text, it's certainly sort of thematically or tonally true. But yeah, but there should be. There should be. Um, and Let me ask that question first, which is that does does that argument, how important is that sort of contention or point to address as we unravel the Cook versus Trump, the Federal Reserve governor case?
Well,
Is
I'm
that
sort of gonna cheat because I'm a formalist, and so I don't care about oh, the law ought to be this or it should be this, because I'm a formalist and I believe law derives from certain formalistic rules. Now, ultimately, I'm a formalist because I believe formalism is good. So in a way, it's functionalism all the way down. In a way, it's normativity all the way down. And I grant that and I accept that. But I believe formal legal interpretation, formalist constitutional interpretation is good for a number of reasons, rooted in my understanding of the rule of law, of popular sovereignty, about where rules should come from, about the moral intuitions of the people versus of judges, right? And so I have all these reasons why I'm a formalist. And that means that, you follow the formalist rules to their conclusion, and because of the overarching normative desirability of doing so, even if that means on the lower order question, you might get a normatively undesirable outcome. But I confess that it's easy enough for me to say that when I think the formalist interpretation of the Constitution leads to results that I happen to like, right? I mean, it makes it easier to sleep at night if that's sort of your view. And in this case, like, I'm not concerned about the Fed. Like, I don't think the Fed should be different. I mean, it should be a little different, but certainly not as it's currently structured, because I think they're political and I think they make lots of mistakes. And so I'm just very dubious of this notion that anybody with wielding power is independent. Independent of what? politics, political views, nonsense, nonsense. They're independent maybe of the president, but even then, they'll tend to support the presidents that they like. So, the normative views just, it doesn't speak to me. But I'm a radical formalist.
Okay. I mean, I could push, but and maybe I will if we have time, because really, um, I want to make sure we give sufficient airtime to the Cook case,
Sure.
because one of the things that is so interesting, I think, about Cook is that it's being litigated. That is, the removal was pursued in a very different way than what we've been talking about, and it's being litigated accordingly. In a different way than, say, whether we go back to 1935 or we talk about the Slaughter case, argued in December. So if I can make you do a little bit of the lifting here, which is just to sort of set the stage for us on Cook, um, and then as part of that, I do think it's significant that the court's rulings on the emergency docket, right? Cook has kept the job. Cook has kept her job. So I'll stop there.
Yeah, so the Cook case is interesting because unlike in the not slaughterhouse, different case, different important case. Unlike the ongoing Slaughter case. Here, the president did purport to remove Lisa Cook from the Federal Reserve Board for cause because she's been credibly accused of, I guess, mortgage fraud, which is not unrelated, right, to the job. Now, the statute only says cause. It doesn't say inefficiency, neglect of duty, or malfeasance. Maybe this would count as malfeasance, though usually it's malfeasance in office. Is it other malfeasance while in office? Kind of interesting. So if it had specified it, it might be a harder case. But it doesn't. It just says for cause. So there are really two questions here. And you could actually see the case being decided deciding either of the questions first. There's some merit to doing either question first. The first question is a Federal Reserve different? Right? If it's not different, then the president can remove Lisa Cook for any reason. The president doesn't even have to cite cause, right? I've argued that the Federal Reserve is not different and and the Supreme Court has said otherwise only on its interim docket, right? It has not been like this final airing on the merits. But even if one thinks the Federal Reserve is different, such that for cause restrictions are okay, it then raises the question, okay, how judicially enforceable are the for cause restrictions? And or, is this cause to remove this being credibly accused of mortgage fraud? And my sense is the court will start with the second question so it doesn't have to decide the first question, though it's also like, why did it grant the case? Well, I guess it granted the case because she was removed, right? And so it has to address this. But I think it's likely going to say whether the Federal Reserve is different or not, we'll put that aside for another day. Here, the president is purporting to remove Lisa Cook for cause. Whatever cause is, surely being credibly accused of mortgage fraud when you are partly in charge of the mortgage industry counts as cause. Now, this is not a foolproof case, right? Because, well, credibly accused, what if she's innocent, right? What if these are concocted, right? And the fraud, to the extent it exists, was out of her office, although related to things she does in her office. It's not like she used her powers in a, corrupt way. She
And I
just,
just want to, if I
yeah,
can, just to say that, of course, in her brief, she disputes even the
right,
contention that that it's a credible accusation. Just to
right,
be fair on that
right,
side, that is,
right. Which I would say too if I was accused of something. But okay, but so I just don't think so. So it's tricky because so everything you've just said actually makes me now doubt the analysis I've just done because maybe they will want to say the Fed isn't different. So Trump, right? Because they would have to then. So if they don't say the Fed isn't different, Trump could fire. And if they don't say whether it's different or not, surely this is cause. If they don't do one of those two things, which is sort of the easy way out, they're going to have to decide whether this was cause. And that gets ugly. Like, what are they going to say? Like, you need a hearing? Now, this isn't crazy, actually. And when's the briefing due in this case? Was it already done? Because now I'm thinking I should have written a brief, but maybe
no.
somebody else will write a brief.
The last thing I saw on SCOTUS was that there was supplemental briefing related to the interim docket, and I think those were filed in late December. So
So
I don't
I
know.
should because I think it's being argued this
Yeah, I think
next
next
week,
week.
right? Oh
Yeah.
well. Um,
Um,
so because I'm sure Chief Justice Roberts is listening, and Gorsuch and the others, uh, Aditya Bamzai has a really interesting piece on the only, really the only, though there's some question if it was the only actual for cause removals that were affected. These were actually both effected by President Taft when he was president, which is kind of funny because he thought, of course, that he had his plenary removal power. But he removed two officers who were protected by for cause. And before doing so, they had in a hearing, an adjudication within the executive branch to determine if there was cause to remove. Now, this isn't crazy because if you go back to the Shurtleff case, where there were these for cause restrictions, but there was no limit on the tenure of the office. So it's like, wait, so you serve for life unless you're removed for cause? And the justices said, no, you can remove for any reason. But if you want to remove for cause, you must do an adjudication to establish the cause because that harms the reputation of the officer. It impugns the character of the officer. But if you're just removing for a policy disagreement or you want your own people in there, that's not cause. You don't need an adjudication. The reputation of the officer is intact. So maybe the court, now that I'm gaming this out, will say, we don't know if the Federal Reserve is different. We don't know if there's cause. But looking at the Taft precedent from when Taft was president, the 1912 precedent, was it 1912? No, I think
I'm not
confusingly.
sure. I have
I
to
think
say
it
I
was I think it
uh-huh.
was 1912. But anyway, it's because that's when he lost, right, to Wilson, I think later that year. I think it was in 1912. The removal and you look at the Shurtleff case. If you're going to remove for cause, you need to have some sort of an adjudication in the executive branch to establish the cause, whether or not you have other reasons to remove, and those other reasons would be constitutional. Maybe that's like a clean way to actually resolve this case
So
that's somewhat consistent with historical precedent.
that is, and where we are now, that is, the more we approach the weeds, if you will, or the particulars, that is, the more I think interesting and or challenging. That is, so what would this look like in terms of um, procedure, decision maker, rights of appeal, and all of that? Um, when I did a podcast back in the fall with Bo Bauman about this Trump versus Cook. And at the time, it was, of course, Cook versus Trump. It was serendipitously, we did it shortly after the district court ruled on the preliminary injunction. I hope I'm being fair to how I understood what he was saying. He thought that is, these questions may lead to, in effect, this is my shorthand, right? Almost like a 701A2. That is, this is not justiciable. That is, it's, there aren't standards here for a court to apply. Although I have to say, in how you describe, Taft's actions and then what happened subsequently, no, there are. That is,
That's right.
we can find
At
a
least
precedent.
procedurally. At least
Yes, that is,
procedurally,
it
right?
provides a structure and a process for
Which is
how to do that.
classic. It's just classic arbitrary and capricious review, right? Classic judicial review of administrative action. It's like, look, we're not going to supplant your judgment with ours, but we're going to make sure that you consider the relevant factors and follow the relevant processes, and maybe they could do something here too, which is super interesting, actually, whether they do that. Yeah, I mean, the problem, of course, if it is judicially reviewable, the for cause restrictions. I mean, this is all the more reason why I think Congress can't do this under the necessary and proper clause. If the president thinks there's the laws aren't being faithfully executed, look, it can be total pretext for something else. But suppose the president states that, and the court says, no, actually, we think the laws are being faithfully executed, and you're engaged in a pretextual removal. Okay, so has the court now transferred to itself the final say over whether the laws are being faithfully executed, which is the same problem as giving the Senate, right? It's a judicial veto instead of a legislative veto, which is all the reason why I think Congress, under the necessary and proper clause, all the more reason why I don't think it has this power. So if the Federal Reserve is different and cause can be imposed, and they want to do something beyond merely policing the procedure, the court is going to have to be ready to decide, that the president has not acted in good, maybe not good faith, but to assess the matter for itself, and that's Is it really going to want to do that? So now that we're having this part of the conversation, this is good because, like I wasn't entirely sure what I thought about all these subsidiary issues. I think that just the clean way to do it is to say the Fed isn't different. Because what a can of worms they're opening up if the Fed is different.
Um, having having identified several cans of worms, um, do you have any, if you had to, speculate, prognosticate, what do you think the court will do in the case? And I know that, I mean, the briefs have been written, oral argument hasn't taken place. Um, I seem to, that is, and I think there's a conventional wisdom to what I'm about to say. That is, well, they've really singled out the Fed. They've really, in other words, they've created this, they suggested there's this strong Fed exception, um, which I think the Trump administration met, right, by saying, we're going to do this according to the statute. That is, we're going to say that we have cause. Any sense of how this might, you know, be decided, unspool, whatever the appropriate verb is?
I have no sense. I mean, I cannot prognosticate here. I mean, obviously, we have three judges who are going to say the four cause restrictions are okay, whether there's a Fed exception or not, right? And if Slaughter comes out the other way, they're going to say there's a Fed exception, right? This is Sotomayor, Jackson, Kagan. And then the question is, are they willing, what are they willing to say about cause? Because they're going to have to say something. They're going to have to either decide the procedural point, which is the cleanest way to say you need some process because cause is allowed or these restrictions are allowed. There must be some internal agency process. And my guess is they'll defer to another day whether courts can second guess the president's determination here. So that's probably what they're going to do. But the other six, right? I mean, this is kind of interesting. Like we're going to get some sort of split. Maybe we'll get three, maybe we'll get a Kavanaugh and a Roberts, to say that the Fed is different and four cause restrictions are okay, in which case they would be joining the three liberals to form a majority on that question. And then you have, the other four Republican appointed. This is kind of fun, but I don't know who knows what they're really going to do, right? Who might say anything like there is no Fed exception, or if there is a Fed exception, surely the cause has been met in this case. And so I wouldn't be surprised based on what the liberal justices are going to do, and we basically know what they're going to do. They only need to clobber together two of the six, right? They need to siphon off two of the other six to form a majority of some kind. And so my guess is they'll get Roberts and Kavanaugh to say the Fed is different. And then the only question is whether they'll, join the others to say whatever cause is, this is it, or do we need some sort of process? But this will be Justice Kagan's opportunity to rise to the occasion, like she has often done, and convince Roberts and Kavanaugh to do something, kind of narrow and technical. But I don't know. I mean, there are so many cans of worms here that are they're going to open up something. And the question is, how do they
Yeah.
minimize that?
And then one more, if I can sort of, right, I'm a civil procedure person too. So, right, if there is a pending case in the district court, that is to say, we are here on sort of an expedited basis, and oh, do we remand and say to the district court, that is, we'll keep the stay in place, but you aren't the adjudicator, you aren't the decision maker. That is to say, it has to be there has to be some what you refer to as an agency process, or could we say that is the district court will decide. That is, we'll in effect hold the hearing in the litigation because who would be more qualified in a sense
And then what
to
kind of
adjudicate
deference,
it?
and then what kind of deference would an appellate court, including the Supreme Court, give the factual findings, right, of the lower courts, right? I mean, whether it's substantial evidence or clear error, I mean, normally there's an appellate standard that's highly deferential. And so then the conclusion is that a district court is in a position of disagreeing. One of 600 district judges is in a position of disagreeing with the president's four cause determination, and then we defer to that. And if we don't defer to that, we have to make our own findings and have a trial in the Supreme Court. This whole thing is crazy. This whole thing makes me think that, like, I did not fully appreciate until our conversation, Roger, that the can of worms that this could open up. And so there's a clean way. There's a clean way to resolve all of this, which is the Fed isn't different, which has the virtue of being the historically and textually correct answer.
Um, this is such a tempting place for us to end. Um, and in fact, I'm going to err on the side of ending there because I do think it's an appropriate concluding point for us. Thank you so much. It's been a real pleasure. And I will say this as we are still recording. That is, you provided sort of so much elaboration, explanation that really every answer advanced the ball. So thank you so
Hi.
much.
Well, they were good questions. How about that? So thank you so much. This was a lot of fun.
Well, again, thank you so much, Elon. It's been a pleasure talking to you. And like you, on pins and needles for oral argument next week and the decision later this term. Thank you.
Thank you.